the fighting and training to be a mixed martial arts cage fighter or competitive jiu-jitsu fighter is much different than the training that the Minneapolis Police Department uses. And so ultimately, that type of testimony, I think, is prejudicial. I think it's irrelevant. It's not, it should not be permitted.
All right. State's response? Mr. Frank.
Good morning, Your Honor. Thank you. Donald Williams, we will be able to lay foundation for exactly what is at issue here. Donald Williams began wrestling at age 13. He wrestled into his college years. Wrestling, of course, is all about leverage and weight and force through body-to-body contact. In about 2009 or 2010, he started training in mixed martial arts. And during that 10 years leading up to this incident, since he was age 21 or 22, was in the gym every day for 8 hours a day training in mixed martial arts. He has boxed or fought 18 to 20 professional fights and has told us that in his training, he has trained with police officers from various police departments when they come to the same gym and do training there. We know that use of force officers will testify that they have also taught jiu-jitsu moves as part of their use of force training, because it is using the application of force and body weight to control other people. We expect Mr. Williams to testify that as part of his training, they are taught chokeholds, and that is a way of controlling another person by rendering them unconscious. And as part of that, he knows how it feels to be rendered unconscious. And they actually practice that in their training. They practice it because, in part, they have to know when it's time to tap out, right? When they know it's gone too far, and if it goes too far, somebody can be seriously injured. Somebody can die. That's all part of his training and his experience in mixed martial arts over many years. They're also taught to know how to control their breathing when they're put into a chokehold, so that they are not, so that they don't go too far and end up dying as a result of it. The defense will no doubt, as their experts have opined, allege that the bystanders were an unruly mob, and that Mr. Williams was one of the most vocal members of that unruly mob. This unruly mob that consisted of some teenage girls, a 9-year-old, an elderly gentleman who was trying to help, and Mr. Williams, who was quite vocal. Anybody who has seen the bystander video knows who we are talking about. And what's important in large part about Mr. Williams' testimony is he was so vocal because he knew all of this. He knew how serious this situation was. He knew that Chauvin was killing this man.
Ooh.
Mr. Chauvin was killing this man because Mr. Williams knew from 10 years of training and experience in mixed martial arts alone that this was very dangerous and was most likely cutting off his blood supply and his ability to breathe.
Can I ask you a question? If I recall from the probable cause motions and that, when we had some of the videotapes as part of the record, Mr. Williams, did he use the phrase blood choke or something to that effect, saying something to the officers?
That's correct, Your Honor. And what a blood choke is it, it's different than we think of choking on a piece of food, right? It's affecting blood flow. And Mr. Williams will explain that a blood choke is where you do that. You try to interfere with the blood flow to render that person unconscious. And he recognized aspects of that in what Mr. Chauvin was doing at the scene. He sees that. He's standing feet away and he's seeing it. That's partly why he is so agitated and so vocal at the scene. not because he's a rolling 30s blood member, he's clearly not, because he's a mixed martial arts person, 10 years experience, who knows how serious this is, and something has to be done. And that's why he's so expressive. He can see in Mr. Chauvin's position that Mr. Chauvin's knee is on the neck. It's perpendicular to the spine in the area between the shoulder blade and the ear, where it could interfere with blood flow to the brain and the rest of the body. And that's why it's so serious. Mr. Williams will also testify to what he calls a shimmy. And it's a move that mixed martial arts athletes are trained to do to tighten that chokehold. And it's a body movement that Mr. Williams will point out for the jurors at trial, where it can be seen that Mr. Chauvin is rocking back and forth to secure that hold, to secure Mr. Floyd to the ground. So his training and experience in everything from wrestling through all of his mixed martial arts and boxing is relevant to what he is seeing and what he is explaining and what he is trying to tell Mr. Chauvin and the other officers to do. And that's get off him and get him help because you're killing him. So there is foundation for that testimony through his training and experience. We're not testifying that we're not going to try and qualify him as a medical doctor, but it's relevant and it helps the jury understand, first of all, why Mr. Williams is so upset, and secondly, what he is seeing from mere feet away, live and in person, about what Mr. Chauvin is doing to Mr. Floyd. So that foundation we will be able to lay through his testimony, all of which has been disclosed, and will be offered for those opinions. So we would ask the court to deny this motion.
All right, I think at some point it becomes a medical opinion, and I don't think the state is offering it for that purpose. For example, that it was the hold itself which contributed to the death of Mr. Floyd. It appears to me that this is actually similar to the firefighter, where this person can talk about their training and experience. And specifically, I think in this case, because he does say, and it is audible on the video, that the term's blood choke, I think he is entitled to say what his experience is and to explain what he meant by that, and also the shimmy, to be honest, that that's what he thought he saw, and that he thought it had gone too far, because in his training, once a person is unconscious, I assume this is what you're talking about, Mr. Frank, that once he's unconscious, that the hold should be lifted. That's his training. He's not to opine on anything else. He can't go and say this is what caused his death or this is what caused him to go unconscious. All he can do is talk about his observations, and based on his experience, that he thought it was a blood chokehold, that he wasn't seeing a shimmy, to explain what those terms mean according to his experience. And I would even allow him to say, and based on his experience, he thought that the hold was kept on too long. I think beyond that, then we start talking about medical opinions. Did it cause the death? Did it cause him to be unconscious? I think he can talk a lot about his observations and explaining what he thought about the hold itself and how that it went too long. Is that kind of clarify for the state where I'm drawing that line?
It does, Your Honor.
Mr. Nelson?
It does.
All right. Let's move on to the next.
Thank you, Your Honor. The next motion is number 23. I think this is, again, very similar to the motion yesterday involving Genevieve Hansen. Again, we're not contesting that firefighters who responded to the scene can testify as to their observations, as to the course of medical treatment that they attempted to use in the resuscitative efforts for Mr. Floyd, but ultimately it's just their opinion as to what the cause and manner of death were. I mean, that's what I'm seeking to exclude.
All right. Is the state attempting to do so? Mr. Blackwell.
Good morning again, Your Honor.
Good morning.
No, we're not, and it's mostly just to be clear about sort of what we mean. We talk about cause and manner of death, or not testifying about any contributing factors. What does that mean? The paramedics are obviously there on the scene, doing everything they can to revive George Floyd's life, who had been without a pulse for several minutes, and the jury is entitled to know what they saw, how they reacted to it, what treatment modalities they decided to employ, which ones they decided not to, and then when they get to Hennepin County to the emergency room, where they will be further attempting to revive Mr. Floyd, what they reported based on their observations and experience. So that's all factual, and that is what we would intend to impart to the jury, Your Honor.
How is this different than the rulings I made on the off-duty firefighter?
I don't think it is.
Whether a person's off duty or on duty, when they have virtually the same qualifications, I would allow the same type of evidence. Accordingly, what the firefighters saw when they arrived, the symptoms they saw, whether the person was in medical distress, what techniques they thought were appropriate to intervene, all the things that I said for the off-duty firefighter I think apply equally to the other one. It's just observations of what they saw, what attempts were made of revival or resuscitation. I think it's the same line as drawn as for the off-duty firefighter. Okay?
Very well, Your Honor.
Thank you. Mr. Nelson.
Your Honor, I think we could probably quickly dispatch of number 25 and 31 as well. 25 being exclusion of any reference to Mr. Chauvin's invocation of his Fifth Amendment rights. I had a brief chat with Mr. Frank, just for point of clarification. We are not seeking to suppress any statements that were made or that were captured on body camera footage. We agree that that's admissible, and in fact we've repeatedly stipulated or offered to stipulate to the admissibility of the body-worn cameras from the incident. Likewise, other officers capture conversations and their body cameras. For example, a sergeant responds, asks what happened. Custodial, it's non-testimonial. We're stipulating that that all comes in. Ultimately, when this turns to a critical incident, however, Mr. Chauvin is brought to room 100 of the City Hall, which is the standard practice in critical incidents here in Minneapolis, and is afforded an opportunity to consult with a lawyer at that time. The lawyer who responded, they didn't make a statement, and I believe ultimately we are in agreement that there would be no reference to the invocation of the Fifth Amendment rights at that point beyond. Anything that happened before that's captured on body camera, we agree is admissible.
Mr. Frank, sounds like we're in agreement.
Yeah, with our understanding that that is the sole basis of this motion, we would agree that the council decision to not give a statement is off limits.
So you're saying that you could somehow elicit pre-custody that he did not give a statement?
Well, there are pre-custody statements and lack of statements that would not be covered by the Fifth Amendment, correct?
I think it's always complicated with a peace officer in this situation with the Castigar and Garrity and the statutory protections. So it's not like a civilian on pre-arrest silence. There's all these other statutes that protect them, and has everybody thought about that?
Well, I would say not fully, Your Honor, because I'm not sure of the extent that those cases would apply to the very situations that Mr. Nelson was talking about.
So ultimately, Your Honor, the prior to him being brought down to room 100, before this was deemed a critical incident, everything is captured, literally everything is captured on one body camera or another. I don't believe that those constitute garrity statements. They're not forced statements. They're not being, he's talking with Officer King or he's talking with Officer Tao at the scene. No authority figure from the police department is compelling him to make those statements. So I don't think garrity applies in that context. Again, I agree all of that is within bounds, anything that is or isn't said. But in terms of saying, once he gets to room 100 and a lawyer is afforded to him and a lawyer counsels him, that's the basis of the motion. I think it would be improper, for example, if the state says, well, Mr. Chauvin didn't make a statement to his sergeant in that instance. I think that would be improper. And also, in this situation, statements were made. He was standing there right next to the other officers who were involved when they gave the public safety kind of statement about what happened. And so again, I think that's all admissible. I would agree that that's all admissible, but an inference that his silence in that circumstance would not be proper. I mean,
Right.
All right, an adoption of a statement by silence would still be admissible, is not prohibited by this. So what we understand counsel to be saying is he is not raising any issue with respect to anything said up to the council decision at City Hall. But we do not agree that if there were adopted statements or silence, statements by silence, prior to that point, that they would be covered by the Fifth Amendment either. And the case law that the court is talking about, well, I guess I'll just leave it at that, because that's our understanding of the motion.
I think I was referring to when critical incident is a term of art that we all use, and I think when you start declaring a critical incident, it kicks in potential garrity and Castigar issues. But it sounds like you're not intending to offer any evidence of silence, pre-arrest silence between it's a critical incident to arrest. Or are you?
We might.
All right, we're going to have to probably have a conference off the record when we get to that point in trial.
Okay.
So I'm going to reserve ruling. I think everything up to all the body cams, et cetera, up to the time of a critical incident, you would agree, Mr. Nelson, that all is appropriate?
I agree.
Okay, and the state agrees with that. It's that question of critical incident declaration to arrest. It's pre-arrest silence, but does the fact that it was declared a critical incident. So let's talk a little bit more about that when we get to that point in trial. But those are the limits for now. And if you have any other authority that you can throw my way, and I may be sending you down a rabbit hole, I recognize that, but I would like to make sure we cover all the unique aspects of this situation.
Okay.
Mr. Nelson.
Thanks. And I think we can also quickly deal with number 31, which is a motion to exclude the statements of officers Tao and Lane. And for points of clarification, officers Tao and Lane gave tape-recorded voluntary statements to the BCA and in connection with the FBI, counseled by attorneys. They signed criminal investigation warnings, understanding that their statements can't be used or could be used against them. That's all I'm talking about. I'm not, again, talking about what's on the body camera footage or those statements. I believe, based on the submissions the state has already agreed to, that they agree that that's testimonial evidence, that I would not have the ability to cross-examine those other witnesses. I confirmed with each of the attorneys last night that they are not permitting their clients to testify in this trial. I would have no ability to cross-examine those particular statements. Anything else, again, I think is fair game.
Is the state intending on offering any of that? Mr. Frank?
We would not offer them chief, but there is the issue of expert reliance. I suspect both sides' experts have relied on those. So I just want to make that clear.
Well, I think they could say that they have reviewed the statements of those officers, but that doesn't mean, and I know things could be admissible to show the basis of the officer's opinion, or the expert's opinion. But I think we're not just going to, I'm not going to let you do it unless you get permission from the court at the time and show a good need to actually get the substance to form the basis of the expert. Because the expert's testimony is not supposed to be used as a backdoor to get in otherwise inadmissible hearsay.
That's understood, Your Honor. That's fine.
Okay. So just to be clear, I will allow your experts to say they did review those statements. That's it, at this point.
And then we have number 26, which is a motion to exclude any testimony or reference to a blue line of silence or some sort of conspiracy of police officers to remain silent and not cooperate with investigations of other police officers. I believe in this case, there would be absolutely no evidence of that. Every single police officer made statements. They all cooperated. They all went into the BCA or the FBI. They made statements. They were represented by attorneys again. So there is no lack of cooperation by the Minneapolis Police Department in this case. And I think that any reference to that would simply be to try to inflame the passions of the jury or create some sort of a conspiracy that the officers are just trying to cover themselves or protect one of their own.
State's response?
Your Honor, you want me to remain here?
I think as long as we're picking up your voice on the microphone, you can stay there. Maybe pull the microphone a little closer.
Your Honor, I would say that, well, by and large, the Minneapolis Police Department and its personnel have been professional and cooperative. I think it could be argued, we cannot say entirely, but by and large, for the most part. We do not intend, for instance, an opening statement to make statements about a blue line or something as represented in this motion. However, we cannot be, it's our position, prohibited at this point from raising bias if that becomes apparent during testimony at trial. And that is possible. And so I think this motion is in that sense then premature because it should be determined on a witness by witness basis. If bias comes up that looks like this during trial, we should be allowed to explore it for that particular witness.
Perhaps, but these are loaded rhetorical devices that have been criticized by many courts because it is inflammatory to talk about a wall of silence, a blue line. In fact, I think the original thin blue line phrase came from a defense attorney talking about their client being part of the thin blue line that protects us against, or protects civilization against anarchy. So it actually, I think its origins are not in prosecution. And the problem is it's a rhetorical device that is inflammatory and goes towards culture. And I'm unlikely to allow you to do it in any case, but if you think it arises as necessary and as evidence of bias, let's do a sidebar and decide that. Right now, I cannot conceive of when this type of rhetorical device is appropriate. So we'll go with that.
Thank you.
And I believe we added number 33, or is there another one? Just 33 is left?
Yeah, and just just for the record, all of these motions in limine are based on the record as we currently know it. Things in trial happen differently, and so if you think a door has been opened or otherwise there are other circumstances which change, we can always do a sidebar to revisit if the circumstances call for it.
Understood.
Okay, Mr. Nelson.
Your Honor, then the last motion we have agreed to deal with today is number 33, which is the spark of life, limiting the spark of life. Again, not questioning the state's ability to present spark of life evidence, just wanted to make it certain that the spark of life evidence is actually offered for the purposes, the permissible purposes, and just to caution the spark of life witness to know the appropriate bounds or risk opening the door to other character evidence.
And what's the state's intent on that? Maybe I should have you cover the lectern.
And I should say, Mr. Blackwell and I did have, this is kind of an aside, we had a brief conversation this morning about their spark of life witness, and he asked, Mr. Blackwell asked if we could exclude the spark of life witness from the court's prohibition of watching the testimony, the live streaming testimony, because they're only being called for spark of life. I have no objection to that, Your Honor. I think that that's reasonable, and that Mr. Floyd's family members should otherwise be able to, that as long as they're not testifying, with the exception of this person.
And that is my general practice,
Yeah.
is to allow family members who are spark of life witnesses to be able to watch and be a part of the trial, not be sequestered.
Yeah. And we're agreeable to that, Your Honor.
So, Mr. Frank, why don't you come on up and give me an idea of what you anticipate your spark of life testimony would be?
Your Honor, I know this court is quite familiar over the years with the spark of life doctrine, maybe giving it too much of a fancy name, but that's really been a central part of murder cases for decades here in Minnesota. Courts have, the appellate courts have recognized a long list of things that are appropriate to cover in spark of life: photographs, testimony about their childhood, their education, their career, photographs of the family, family members, and discussion of their occupation. All that comes from Evans. I think really Morrow is one of the cases that does a nice job of describing some of the case law, but it really gets to this term spark of life, which I always thought came out of Graham decades ago, that the person that we oftentimes just gets referred to as victim is actually a human being imbued with a spark of life, that this puts some personal nature back into the case for somebody who's treated so impersonally, unfortunately, by the system. And so courts have allowed this when it's for that purpose, not unduly inflammatory or prejudicial. And so we fully intend to do that with respect to Mr. Floyd. We will have photographs of Mr. Floyd at various stages of his life. We will have, Your Honor, I think 2 witnesses that would qualify as spark of life, because one is a family member who would talk about Mr. Floyd's family and his growing up and being a brother to this witness. And as many people know, during the incident, Mr. Floyd references his mother, and so there will be discussions about that, why that was so important to him. Another spark of life witness will talk about more contemporaneous things in Mr. Floyd's life since he came to Minnesota, and quite frankly will also cover some factual elements based on what we foresee as attempts to sort of denigrate Mr. Floyd's character. This person will also be addressing some of Mr. Floyd's life, and so it really will be somewhat factual outside of spark of life.
When you say you anticipate that there will be evidence to denigrate Mr. Floyd's life, why I think I've been pretty clear. I'm not allowing that.
Maybe denigrate was too strong of a word, Your Honor. I apologize. Obviously his drug use is going to be an issue in this case. The defense, is going to portray that as a cause, and that becomes part of the medical case then. So there will be discussion about that. There will be some evidence about that, and so that's why I want to be clear that one of the spark of life witnesses is certainly going to talk about more things than just what's typical and covered in spark of life, but she will do that as well. So just to preview that for the court, that's what we anticipate doing. We will not, well, let me say it this way, we understand what opening the door means, and we will not run afoul of that, though there is some chance that we may ask the court to give us some guidance on that, specifically when it comes to that testimony and at that point in the trial, just to be clear with everybody about that.
Yeah, I think we are all familiar, and Mr. Nelson, I'm going to ask you follow-up questions in just a second. We're all familiar with, I think, the spark of life doctrine, that essentially, like you say, that this is not just a person who we label victim, and we depersonalize the person, that Mr. Floyd in this case is entitled to have the jury realize he was a human being, he was loved, he had a family. I agree with all that. I think if it's basically evidence that will not call for cross-examination, I think that's generally well within the bounds. I guess, and I don't have a problem with two, as long as we're not spending too much time. There's also the case law that says it should not go on and become character evidence. I'm not allowing a lot of the past that would amount to character evidence, and I'm specifically concerned here about, and it may be true, I'm not saying this, but that Mr. Floyd was described as a gentle giant. As soon as you start getting into propensity for violence or propensity for peacefulness, I think then we're getting into character evidence, and then that does open the door for the defense to cross-examine about his character for peacefulness. Everything else, how he grew up, some pictures, that he was loved, that he was a wonderful father, brother, nephew, all that stuff I think is permissible. Obviously, if we don't go on too long, because it distracts from the merits on what happened. But that's my concern on the line, is that as soon as we start getting into character evidence, number one, I don't think it's 404A permissible, because it's not, I don't think you don't get a chance to offer peacefulness to the victim until the defense claims that Mr. Floyd, in this case, was an aggressor at the beginning. And we have videotape to show what actually happened as far as aggression or not. Does this make sense, Mr. Frank?
It does, Your Honor. And what I guess what I was trying to get at earlier is, to me, it's not opening the door if a witness says he was loved by everybody.
Oh, of course not.
He was fun to be around. He enjoyed life. We did things together. We went out. We had fun. That doesn't open the door to the kinds of things that the court has ruled inadmissible otherwise.
Absolutely.
So it was there. I was saying, let's have that conversation if we think there's a problem before we're calling that witness and putting them on the stand, because they will talk about that, and they will talk about him being loved and being part of a family. And sure, he had some problems he was dealing with in his life. We will talk about that, and that will lead into these other factual issues about the issues in the case.
Well, and I think if, for example, you mentioned the use of drugs, and if there's any discussion of his struggle with drugs, that's certainly, I think, permissible spark of life. It does not open the door to a lot of the things that we've been talking about. My concern is, because really, if they're admitting that he had struggles, I don't see that the defense has the ability to cross-examine further about that. I can't think of it, at least. I'll put it this way. If you think that opens the door, you better have a sidebar about that, because I don't see it as discussion of use of drugs does not open the door to further past acts, in my view. For example, it does not open the door to the May 16th, 2019 case. But my concern was more descriptions of his character for peacefulness, because that, I think, would open the door to the May 16th case and other priors that we're aware of, because it's proper cross-examination. You say X, what about Y? So that was my big concern about the spark of life. I think everything you've described is perfectly permissible in spark of life testimony. Mr. Nelson,
You had two questions for me?
I just kind of your thoughts there. Yeah, why don't you go to the lectern? It's a little easier.
Your Honor, I agree. And that's the question, is because a lot of what we've seen in the media and descriptions would, I think, open the door to impermissible, what you have ruled is impermissible character evidence, but it would certainly open the door. The issues, that were ultimately surrounding his drug use and his drug abuse history do play a very central role in ultimately the cause of death. Did he have a tolerance for a particular drug? Would that tolerance somehow make levels that were in his system more survivable to him? Does that make sense? Trying to be as opaque as I can at this point.
Well, let's put it this way. If the medical examiner says that such history of drug use could affect their opinion as to whether drugs were a cause of death, I think it's permissible. My guess is they're going to say whether or not he was a drug addict with a long history of drug use, or he was, this was the first time he ever used drugs, it wouldn't have made a difference on their opinion. Then I don't think you get into the long history because it's not proper examination. If the doctor says, doesn't matter, that's not relevant to my medical opinion, I don't think it's relevant for us to get into it. But again, I'm kind of predicting, I don't know what the doctor's going to say. And
right. I don't think we'll be in a situation where anyone's saying it's not a relevant concern.
All right.
On either side.
Let's deal with the bounds of the drug addiction evidence when it comes up.
Okay.
And this actually is why you'll notice on the trial schedule, I have the jury showing up by 9:15 to start at 9:30, but every day we are in session at 9 o'clock to talk about legal issues. This is kind of what I've reserved it for, is fleshing out the motions in limine in real time.
And I believe then with that actually would dispatch with another one of the motions, the defense motions in limine.
Which one is that?
I'd have to look.
Oh, why don't you go ahead and look.
Yep.
If we can get rid of another one, that's fine.
Number 35, Your Honor.
I think that covers it. State agree?
It's reserved basically until we get to that
Right.
point. Right.
Your Honor, this is one I think we need to sort of work through a little more, because what we're alluding to, trying to be, I think, opaque, as Mr. Nelson mentioned, is tolerance to some controlled substances is an issue experts will talk about in this case.
Right.
So the finer points of motion 35 really need to be talked through, and quite frankly, I thought we would probably be able to arrive at some stipulations about what comes in through this,
Okay.
what is underlying number 35.
I think what it comes down to is if an expert says that tolerance is an issue or is relevant to a diagnosis or their opinion, it's some aspect of it will come in then. But unless and until somebody says it's relevant to their diagnosis, their opinion. For example, if the state's witnesses say it doesn't matter, it's not coming in. If the defense expert says it does matter, then I think you have a right to present what the actual state of affairs was.
Yeah, and I'm happy to work with Mr. Frank to try to resolve it through some stipulations. And I think that, again, I think the court is wise in its decision to reserve.
Yeah, I think we're going to reserve it then, but you kind of know where I'm thinking the line might be. And again, that's why we're going to be 9 o'clock, not 8 o'clock after jury selection. So I appreciate your working full days here right now. All right, anything?
I think that was it for today, right?
Mr. Frank, anything else we have?
That's it for today, Your Honor, that we had.
Okay. We're going to take a 10-minute break. Let's come back at 5:02. And we'll start, I think we have juror number 20, who is our next juror, and we'll start with that at 5 to 9. All right, we're in recess. Thank you. And off.